Hi, Judge Gray. All righty. Okay, we're gonna go ahead
Hi.
and get hi. Okay, we're gonna go ahead and get started. Um, my name is Cassandra Johnson, and I'm a senior program manager for the National Council of Juvenile and Family Court Judges. And we are here today for a webinar with our lovely partners, Nija, who I will let introduce themselves after I go over a few housekeeping things. Like I said in the beginning, and Johanna put in the chat, feel free to introduce yourself. Feel free to also put your questions in the chat. I will monitor those. And we also will have time for questions at the end as well if you want to wait till then. So we're going to go ahead and get started. All righty. So, a little bit about the NCJFCJ. We are one of the oldest judicial membership organizations in the country. We have over 30,000 judges and professionals that we have served throughout our tenure, and over 4 million families have been affected by our work. And here are some of the areas for those of you who are not familiar with us. Is it not sharing? Oh, no. Okay, let's start again. There we go. Now, there we go. Okay, so here's our areas of focus. For those of you who are not familiar with the National Council of Juvenile Family Court Judges, here's some of the work we do around behavioral health. We provide trainings around child sex trafficking. We have a whole domestic violence department. We have a data and research department as well. We have military connected families. And of course, we do our tribal courts and ICWA work as well. And our lovely disclaimer that we always have to put out there. The development of the presentation was supported by our lovely grant right here. So the points and or views of your opinions expressed in this presentation are those of the presenters and do not necessarily represent the official position or policies of OJJDP or the U.S. Department of Justice. All righty, I will hand it over.
All right. Good morning, everyone. Mike Wistahoven, Nini Nian, Nikki Borchardt Campbell. I am Paiute and Ute, originally from Cedar City, Utah, and I am the executive director of the Association. And so this morning, we just want to give you a brief introduction about NIJA and the work that we do. We've had a long-standing relationship with that National Council, and we're very not only honored but just really thankful for the opportunity to be able to provide information and education relating to number one tribal courts, but also those laws that affect not only our tribal communities but our tribal children as well. So NIJA is an association roughly since 1969, so about 55 years. And our primary goals, aside from being a membership association, is to work on capacity building with our tribal courts and just generally the justice system. So, we work with our court personnel, our judges, and then really try to reach out holistically to try help tribes create connections with their intertribal departments as well. So here you can see some of our existing and goals, which include, of course, building capacity, advocating for our tribal justice systems. We also work with NCJFCJ with the legislative committee, and we attend Days on the Hills to talk about, the importance of judicial education across the board, but also about tribes as well. And then, of course, ensuring that quality, culturally appropriate tribal judicial education is available nationwide. And then one of the things that we really prioritize our tribal court judges and our state court judges. So improving cooperation between tribes, states, and the federal judiciaries. And then lastly, providing support to tribal judiciaries by creating opportunities for networking and mentorship. So that's a little bit about NIJA. And like I said, we have been working with NCJFCJ for quite some time. We do have a formal relationship with our tribal and state court membership. And so if you have, please feel free to reach out to us. All right, thank you.
Chante washteu napi chiu zapi, tayu shta washtewi imachiapi. I shake your hand with a good heart. Good thinker woman is my Lakota name. My given name is Johanna Farmer, and I am a program attorney at NIJA. I will be facilitating our webinar today, and we would like to hope that from this webinar, you will understand the role of funding in child welfare systems, learn the various funding sources and strategies to optimize the use of available resources, and enhance your capacity as a judge to support children and families in the child welfare system. Next slide. So, why is it important for courts to understand funding? As we all know, child welfare agencies across the United States are charged with protecting and promoting the welfare of children and youth who are at risk or who have been victims of maltreatment. Tribal, state, and local child welfare agencies rely on multiple funding streams to administer programs and services. While many funding sources are available to child welfare agencies, each source has its own unique purposes, eligibility requirements, and limitations, which creates a complex financing structure that is challenging to administer and understand. And each agency's unique funding composition can determine what services are available to children and families and the ways in which child welfare agencies may operate. So, there are a number of reasons why it's important for courts to understand funding. So, courts must understand funding mechanisms to ensure your decisions are aligning with these requirements in the funding streams. Also, understanding that funding requirements shouldn't be the sole driver of decision making in court systems, but that we need to understand them because specific court orders are often required that trigger federal reimbursement for funding. So, if a court's decisions don't meet these standards, then child welfare programs may lose access to critical funding sources. Also, the timeliness in holding hearings can directly impact the eligibility of child welfare agencies to receive certain federal reimbursements. And so, delays in court processes can jeopardize funding. And also, certain funding streams depend on those judicial findings, specific judicial findings in court orders. Courts, as we all know, are integral in ensuring children are not unnecessarily placed into foster care. So, by understanding the funding mechanisms tied to prevention services, judges specifically can make better informed decisions to support early interventions and keep children with their families, while also ensuring that child welfare agencies can receive prevention related funds. Judges who understand how funding is allocated for family support services can work closely with their child welfare agencies to direct families towards these resources, which can ensure better outcomes and make full use of the available funding for child welfare agencies. Of course, we all know courts help oversee the child welfare system and ensure that services are provided, are properly funded, and align with children and families' needs. So when courts understand funding structures, you're better positioned to advocate for appropriate resource allocation. By understanding how funding works, courts can identify gaps in services or areas where resources may be inadequate. Decisions made by courts, including removal, reunification, or adoption, all have funding implications. By understanding these funding mechanisms, courts can help ensure that the appropriate funds are available for long-term care, support, and well-being of children, especially for services like mental health or rehabilitation. And as we'll go into later, we've seen a shift in Title IV-E funding more towards prevention, in part because of decisions that are being made in child welfare agencies and in courts. Courts that understand how funding is tied to outcomes can also help improve data collection and reporting practices, which in turn affects funding eligibility and also can impact system improvements. We all know judges often play a role in advocating for changes in laws or policies that affect child welfare. As Nikki had mentioned, both of our agencies cooperate for funding at the federal level. So understanding these funding mechanisms helps empower courts to advocate effectively for increased resources, policy changes, or reforms in the system in general. Next slide. So there's a lot of child welfare funding sources. So if we go into the next slide, we'll talk specifically about federal child welfare funding. So in fiscal year 2024 alone, the federal government spent $11 billion in child welfare funding. The largest portions are under Title 4E, first for foster care and then for adoption and guardianship. The smallest portion of spending is for Title 4E for prevention. Next slide. So when we talk about Title 4E, to kind of like give the big picture, when we talk about Title 4E and some of the funding that is given to states, tribes, and local agencies, it's under the umbrella of the Social Security Act. So the Social Security Act has all of these titles within it. The ones that are bolded are specifically funding that goes to child welfare agencies for child welfare support. If we go to the next slide, specifically when we talk about Title 4, there are these different parts of Title 4 within the Social Security Act. When we talk about child welfare specifically, a lot of people talk about Title 4B, which is Child and Family Services funding. And then the big one is Title 4E, which is federal payments for foster care, prevention, and permanency. It used to be federal payments for foster care and adoption assistance, but it was amended with the Family First Prevention Act of 2018. And that was really where it kind of shifted to allow for more prevention. And we'll go more into detail about Title 4E and that kind of shift from adoption to looking more at prevention. So that's kind of structurally where Title 4E, Title 4B, the funding kind of falls within the federal legislation. Next slide. So we talk about Title 4E of the Social Security Act. It's administered to child welfare agencies. So courts don't receive funding under Title 4E for child welfare supports, but child welfare agencies do. It helps support the provision of foster care, adoption assistance, guardian assistance for children who meet certain eligibility requirements. The Family First Prevention Services Act that was passed in 2018 funds additionally kinship navigators and also selected services intended to prevent the need for foster care placement in the first place. So it kind of shifted it, the Family First Prevention Services Act. Next slide. So the funding categories under Title 4E are maintenance payments. So maintenance payments includes foster care maintenance payments, adoption, and guardianship maintenance payments. So these are the things that are paid directly to the individuals who have children who are placed in their care. It also funds the administration of child welfare services, and then it funds child welfare information systems. So these are kind of like the databases and case management systems that exist within child welfare system. It also funds training and then funds prevention and then funds also those kinship navigators. Next slide. So here's where Title 4E is a little different for states than it is for tribe. So states automatically receive Title 4E funding. So when it was passed, states were automatically receiving Title 4E funding, but tribes have to apply to receive Title 4E funding. So in 2008, it was the first time that tribes were allowed to access the funding directly or through an agreement with the state. So prior to that, tribes were not receiving any Title 4E funding. Currently, 14 tribes are implementing a Title 4E plan. And so we call those direct Title 4E tribes. They receive funding in the same way that a state does. There are 20 tribes in total that have a Title 4E plan, but of those, 6 of them are not currently implementing Title 4E. It is very intensive to implement, even to become a direct Title 4E tribe. I have a little bit of experience. I worked for the Pasquayaki tribe prior to coming to NIJA, and I worked with the Pasquayaki tribe to become the 8th direct 4E tribe in the country. And it is a very intensive process of changing codes, policies, procedures, making sure you have forms in place, make sure you have training in place. There requires tracking for child welfare agencies. I believe there are over 200 requirements in a Title 4E plan. And so, like I said, it's very intensive. So that's why of the 574 federally recognized tribes, only 14 of them are implementing that direct 4E plan. Additional tribes do receive pass-through funding for 4E. So that's where they come to an agreement with the state, and the state says, here are the provisions that you have to meet in order for us to pass through or give you the Title 4E funding that we're receiving from the federal government. So you have agreement or a contract. Next slide. So we talk about Title 4E. In order to be eligible to receive payments, when a child or a family enters into the child welfare system, they must first pass an income test. So this is the first, limitation for someone to receive Title 4E funding. And then here's where judges come in. There must be removal requirements that are met. So first, a judge must find that remaining in the home is contrary to the welfare of the child and that reasonable or active efforts to prevent foster care were made. So the contrary to the welfare finding has to be made in the first court order about the removal. And then the reasonable efforts finding can be made no later than 60 days from the date of removal. And so when we talk about reasonable or active efforts, the difference is reasonable efforts are the general efforts, and then active efforts are what's required in the Indian Child Welfare Act. Then additionally, they must be placed in a licensed foster home or an other eligible facility. And then they have to meet the age requirements. So the age requirements are birth to, depending on what your state or your tribe requires, anywhere from 18 to 24. Next slide. And then after we've met that initial eligibility requirement, so all the things that were in the last slide, then the child has to continue to meet eligibility requirements under 4E. So this requires them to meet the permanency requirements. So then a judge must find reasonable or active efforts to finalize a permanency plan. And this, depending on what your state or your tribe requires, permanency includes reunification, adoption, guardianship, placement with a fit and willing relative, or another planned permanent living arrangement. And we'll give an example on the next slide of another planned permanent living arrangement. So I think one of the big misconceptions about Title 4E is that it really pushed for adoption as the primary permanency. However, even if you look into the Title 4E Act, the first is always reunification. So permanency does include reunification, and we just need to remember that when we're working with these child welfare cases. And then that finding of reasonable or active efforts to finalize that permanency plan have to be made within 12 to 14 months, and then at least once every 12 months while the child is in foster care. Next slide. So this is another planned permanent living arrangement. So these are the judicial determinations that have to be made. So first you have to determine whether the agency has documented the intensive, ongoing, and unsuccessful efforts to achieve the other permanency. So reunification, adoption, guardianship, or placement with a fit and willing relative. If all of those are not made, then we are documenting that intensive and ongoing efforts have been unsuccessful. And then one of the things is ask the youth about their desired permanency outcome. So what does the youth want their outcome to be for permanency? So that's an important thing that has to be made for this judicial determination. Then a judicial determination explaining why, as of the date of the hearing, that another planned permanent living arrangement is the best permanency plan and provide the compelling reasons why reunification, adoption, legal guardianship, or placement with a fit and willing relative are not within the youth's best interest. And then the court will determine that the agency has taken the steps to ensure that the reasonable and prudent parent standard is being exercised, and the agency has documented that the youth has regular and ongoing opportunities to engage in age appropriate and developmentally appropriate activities. So that reasonable and prudent parent standard and also the opportunities to engage in regular age appropriate and developmentally appropriate activities are also in your other court orders. But this is just an example when we're looking specifically at another planned permanent living arrangement. Next slide. Excuse me, I'm getting over a cold still. So the Title 4E, the Chafee program, which many of you have heard, is what provides support services to youth who are experiencing foster care at age 14 or older are young adults who were formerly in foster care. So this program is specifically designed to help youth transition into adulthood. Whether or not youth are going to be in foster care from the age of 14 until they age out, the idea is that Title 4E and child welfare agencies are ensuring that a child who is in an artificial, child welfare system, that they are being able to transition into adulthood successfully. So Chafee helps assist with education, employment, financial management, housing, emotional support, and assured connections with caring adults. It also includes the educational and training vouchers program to meet post-secondary and education and training needs for youth who are 18 or 14 years or older, or young adults who are formerly in foster care. Next slide. So Title 4E for prevention. So this is offered to youth at imminent risk of foster care, pregnant or parenting youth in care, and parents or caregivers of those children. So formally, under Title 4E, you could only trigger funding at the time of removal. So Title 4E encouraged, in a way, child welfare agencies to remove a child in order for that agency to trigger Title 4E funding. With the Family First Prevention Act, what it does now is say, hey, prior to us removing a child, we can receive funding under Title 4E for the prevention of this family being placed into the child welfare system. So the limitations are pretty heavy, though, on the prevention end right now. So tribes and states have to have an approved prevention plan. So similar to a Title 4E plan, they have to have a prevention plan, what kind of services they're going to provide. And then also prevention services have to be rated by the Title 4E Prevention Services Clearinghouse as meeting the Title 4E evidence standards. So there are 3 levels of evidence standards that are in place. There's promising, supported, and well supported. And if you look into specifically the Family First Prevention Act, it goes into great detail about what promising, supported, and well supported practices are. But promising, that lowest level, is about monitoring someone's progress throughout a program. And then at the end of the program, seeing whether or not they're better off or not than when they first entered the program. It provides support for services in mental health, substance abuse, or in-home parent skill-based programs. And then it cannot be more than 12 months, but additional 12-month periods are permitted. So it could be provided for 12 months prior to removal, but an additional 12 months can be also put in place. Next slide. And then kinship navigators. And I did want to say about going back to the last slide about the prevention programs. I believe there are only a handful right now of programs that are in the Prevention Services Clearinghouse as meeting the Title IV evidence standards. And one of the things that we've been talking about a lot is the difficulty, specifically with tribal populations, and being able to meet these evidence standards. There is a provision in the act that does allow for tribes to request a waiver for a specific program. But part of the issue, of course, with evidence standards is like it requires a certain population. And for tribes, many tribes have very small populations. And so they don't statistically have enough of a population in order to meet those standards. We can go back to the next slide. Yeah. Kinship navigators. So this is intended to ensure kin caregivers have access to services and supports to meet their own needs and the needs of children in care. So this is when we're talking about specifically people who like grandparents raising grandchildren as an example. So it doesn't require child welfare involvement, but it still must meet those Title IV evidence standards. Oh, and this is where through May of 2024, only 5 programs have met the standards of kinship navigators. There are more programs in the prevention services. Sorry, that was my mistake. Next slide. So Title IV-B of the Social Security Act funds formula grants to states and tribes, and it includes the Stephanie Tubbs Jones Child Welfare Services and the Mary Lee Allen Promoting Safe and Stable Families programs. The other funding under Title IV-B are the court improvement programs. So every state has a court improvement program, your CIP. Some of you might sit on your CIP advisory board for your states. And all CIPs do different things. States make determinations about what projects they're working on with their CIP funding. So all states receive funding. And here again is an area where tribes have to compete for court improvement program funding. It's a grant. There are anywhere from 5 to 8 tribes that receive funding when a court improvement program comes out. So if we have 574 tribes, and there is only 1% of those that are receiving funding under court improvement programs. And then it's not sustained funding, it's just a grant fund. So you apply, you receive it, and then it's a 3-year grant program, and then it ends. The other funding under Title IV-B are the monthly caseworker visit grants and then the regional partnership grants. Next slide. So the funding categories under Title IV-B are family preservation, family support, time-limited family reunification, and then adoption, promotion, and support. There are a limitation on Title IV-B funding. So foster care maintenance, adoption assistance, and child care assistance are all limited to the fiscal year 2005 levels. And then there's a limit of 10% on the administration of Title IV-B funds. And then it can't be used for medical or educational cost. Next slide. So the Child Abuse Prevention and Treatment Act is designed to allow states to improve child protective services and provide community-based efforts to prevent child abuse and neglect. It also establishes mandatory reporting laws for suspected child abuse and neglect and puts in place systems for responding to reports of abuse, including mandatory referrals for high-risk cases, and also provides multidisciplinary training. So again, this is one of the areas that tribes do not have access to this funding. It's just for states. Next slide. So the Adoption and Legal Guardianship Incentive, formerly called the Adoption Incentive Payments Program, It allows states and tribes to earn incentive payments for increasing the rate at which children who would otherwise remain in foster care are placed in new permanent adoptive or guardianship families. So, again, we come back to some of the troubles with systems that kind of um, put an emphasis on adoption. And now we're moving kind of away from that. A lot of tribes do not have adoption because they don't believe in the termination of parental rights. Some have cultural or traditional adoptions. And so a lot of tribes had legal guardianships that they were doing, but were not qualifying for the adoption incentives payments. So when the Adoption and Safe Families Act was passed, it shaped a child welfare system that unfortunately disproportionately targets poor families and families of color who face excessive investigations, child removal, and foster care placements. Of course, this can culminate in the termination of parental rights, which is often termed, the civil death penalty for families and is shockingly common, as many of you may know. An estimated 1 in 100 children experience this parental loss, and termination of parental rights has created a new category in the United States of dependent children that are called legal orphans. So, children who no longer have parents, as their parents have had their parental rights terminated, but also they have not been adopted and might never be. The other federal funding sources that exist are Medicaid. So, this provides health services for children who are in foster care. There's also the Temporary Assistance for Needy Families. So TANF does work with families to try to, prevent the removal of children and provide those supports. But TANF also allows for child-only cases, meaning children are placed in care and still able to receive those TANF payments as child-only cases. Then there are social services block grants, which are grants to provide essential social services to help achieve a number of goals like reducing dependency, promoting self sufficiency, protecting children and adults from neglect, abuse, and exploitation, and also helps individuals who are unable to take care of themselves to stay in their homes or find the best institutional arrangements. So both states and tribes receive social services block grants. And then for tribes only, there is Bureau of Indian Affairs or BIA funding. So there are Public Law 93-638, which is called 638 contracts, where a tribe enters into a contract with the federal government to provide the social services for the individuals that are on their land. Then there are tribes who are self-determination, meaning they haven't entered into a contract but are just receiving that direct funding from the federal government. And then there's also Tawahi funding. Next slide. So how courts impact funding. So we talked about it a lot at the beginning, but support for prevention services to reduce children entering into care. So how do we make sure that we are encouraging individuals to receive prevention services in order to prevent a removal of a child? And we all know the trauma that children and families experience when we've removed a child from home. So how do we ensure that prevention services are being provided by our child welfare agencies that we're working with in order to prevent or reduce the number of children who are entering care? Then also making sure your court orders are meeting the standards that are required for eligibility or reimbursement for these child welfare agencies. So that's why it's important to understand the eligibility requirements, the continued eligibility requirements, making sure your digital findings are meeting the requirements that are in place for Title IV-E. Sound and timely decisions. So courts can ensure children and families are receiving the services by understanding those funding mechanisms. Understanding that they're able to access mental health needs, substance abuse treatment, or even in home support services that are funded by the Family First Prevention Services Act.
Hey, Johanna, we had a question in the chat about, I think it was right before, for how are TANF funds accessed for children in jurisdiction?
Cassandra, can you repeat the question again?
No, it's okay. How are TANF funds access for children in jurisdiction? And if you want, it's Judge Hudson, if you want him to expand, but
Yeah, so I'll give an initial answer, and then if it doesn't, fully answer the question, please feel free to, ask more detail. But TANF funds are accessed for child only cases through caseworkers. So the caseworker that is assigned to the child in the child welfare agency can apply to TANF to receive those child only funds for the child. So that's why it's also important that your child welfare agencies are aware that that exists. If they have a good working relationship, like when I worked at Pasquayaki, the adult services who provided the TANF program and the child welfare services were all under the social services department. So they were under one umbrella. And so it was easy to understand that, that service could be provided. And so our caseworkers on the child welfare side were informed that they could apply for TANF funds for child only cases. And then we started to do a lot more work on the prevention side where TANF was kind of identifying maybe families that were struggling and how do we work with our child welfare caseworkers to ensure that we're not removing from the home. Because again, once a child is removed from the home, a family stops receiving TANF services. So if they're, really dependent upon TANF services and then they're losing that funding, then it may be very difficult for them to meet their case plan if they're really struggling because they were relying so much on the TANF services. So we have to be very aware that, a child removal can trigger the stopping of services on a different end. So, Judge, does that help? Okay.
and then also in the chat, Judge Fine added a little bit as well and said the agency would apply on behalf of the child through the tribe. So this is for tribe. If the tribe operates a tribal TANF program, if the tribe does not operate a TANF program, they would apply through the county state where they reside. Thank you, Judge Fine.
And then data accuracy. Sorry, Cassandra. um, Courts impact funding through data accuracy. So, the congressional people are making policy decisions based on what they're seeing. So, all child welfare agencies have to collect, and I'm sure you've all heard the term AFGARs before. So, they're collecting data, and then all of that data is collected by the Administration of Children and Families. And then that's getting taken to Congress and being like, here are our numbers. And so when courts understand data, it can look at the impacts that it causes to child welfare. Also, looking at, of course, it's very important for us to understand child welfare outcomes as well as the strengths and needs that exist within our child welfare agencies. Next slide. It's important to be aware of the challenges in child welfare funding. Of course, budget shortfalls and unpredictable funding, the complexity of funding streams. All we've talked about for the last almost 40 minutes is the complexity and ins and outs. And we didn't even do, this is a child welfare financing 101. We're not even doing a deep dive into it. So every funding stream is very complex. We didn't even get into, besides the state match for Title 4E funding or the tribal match for Title 4E funding, states and tribes also provide funding for their child welfare agencies, and those may have requirements that child welfare agencies are trying to meet. The integration across multiple funding sources. So, how are they integrated? How are they able to use each other? And sometimes I guess it would say the disintegration, right? Like they're not integrated with each other. They're kind of siloed funding streams that you're trying to meet every requirement for each funding stream that a child welfare agency is receiving. Then the administrative burden that exists in child welfare funding, the amount of paperwork that a child welfare social worker, case manager, even the paperwork that you're having to do as a court in order to meet the Title 40 requirements, that administrative burden of child welfare funding is heavy. And then I touched on it throughout um, this webinar about the disparities in funding allocation, in particular to tribal communities, not being able to be direct 4E tribes until 2008, having to compete for grants that states get automatically. So the disparities in funding allocation can really impact the services that are being provided. And then again, when we look at kinship navigators or prevention services and the limitations that are required of those, really can provide a disparity in funding that leans towards, child welfare agencies removing a child in order to receive Title 4E funding. And then the inadequate investment in prevention and family support. I mean, we're moving that direction, but 2018 was not that long ago. And in the meantime, we've had an entire pandemic. So that really, threw a wrench in things at times. But that inadequate investment in prevention and family support services, the more prevention, the less children we have coming into care, the less trauma we're impacting on children and families, the better. Next slide. So, what are strategies that courts can use to support child welfare funding? So, one, engaging children and families, not just in prevention, in your court. How do we get them out of the child welfare system in a timely manner? Supporting those prevention services, collaborating with your child welfare agencies, really being aware of what's going on, like how you can support them as a judge. We talk a lot about the impact of judicial leadership. Then ensuring compliance with the federal requirements. Now that you're aware, you know where these requirements are coming from. You can work, again, going back to that last bullet point, work with the child welfare agency. Are there things that we could do better as a court system in order to make sure that we're meeting those federal requirements? Also, like explaining to families when you're in court, saying, you've met the Title 4E requirements. A family doesn't know what that means. So explaining that to them is a best practice. Advocating for increased resources to child welfare funding is an important part of a strategy for court to support child welfare funding. Next slide. So I know we went through a lot. I wanted to make sure we fit it all in and then allowed some time if anyone had questions.
Yeah, you can either put them in the chat, or if you're comfortable, you can come off mute and ask your question as well. Not seeing any in the chat. But I don't know if there's anything else you wanted to add, or even Nikki.
Hi, this is
Oh,
Christine
wait,
with
there you go.
District
Yeah.
Court. Yeah. Hi, I have a question. That was a lot of information, a lot of information that was somewhat new to me. Um, so I work with kids who haven't been so on the delinquency side of things. However, some of our kids, they haven't lost guardianship. The parents haven't lost guardianship, but they've been placed in like a home setting, and the parents are homeless. So like the child can't thrive with the parent. How would I go about getting services or funding for that family, for a family like that? I don't know if my question makes sense. I don't know how familiar everybody is with Las Vegas or where everyone's from, but we have a probation facility called Pivot Point. And so when kids aren't thriving in the home, but haven't met requirements to get a CPS case, we place them at pivot point. Most of the time, the parents are homeless or they're just not able to care for their children, but they still want to. And I don't know if there's any options to help those families.
So one, Title 4E does, you know, have funding for prevention services.
Mhm.
So those children that are at imminent risk of removal. And then outside of like child welfare funding, there's the McKinney-Vento program, which is for, school age children who are experiencing homelessness.
Okay. I do have a contact for McKinney-Vento. They pay for I can't remember the acceleration programs for our students, but I didn't know that they could do more than that. So
Yeah, and contacting the child welfare agency in your area, I think is always a good step because they'll really be able to tell you, like, here's a situation that we're in, and here's kind of the supports we want to provide for the families that we have in that we're working with.
thank you. That was a lot of information.
Thank you. We had two in the chat. Do you see any movement towards making it easier for tribes to access direct Title 4E funding?
I have not. I haven't, I mean, I haven't seen any movement towards making it any easier for tribes to receive Title 40 funding. I know it's been an issue that's been continually flagged. State child welfare systems are very robust. And so they have a lot of people who are able to work on something, whereas tribes may have very limited funding. Um, but I haven't seen any movement towards that changing, unfortunately.
And I don't know if you'll know this, Johanna, but someone asked, do we know of any trainings that would be or do like a deep dive on the funding structures? So, like kind of what you were talking about, like kind of diving deeper in. And if not, maybe that's something we should do.
Yeah, I mean, one of I know that the federal government does provide some training on 4E when you're like for a tribe specifically to like understand Title 4E. However, I know Casey Family Programs does provide some training. I haven't seen them provide it recently, but they do have some like online trainings about uh, child welfare funding. And then like Cassandra said, we are a training and technical assistance provider. And so if there's specific like one area where you really want to have that like deep dive, we definitely could work with you to provide that deeper dive into specific funding.
Okay. And I'll see who asked that question. I think it was Sherry Harris. So we can also get your contact if you want to talk more offline about a more deep dive training for you. All right, thank you. Yeah, any other questions?
Yeah, I think it's, just appreciate everyone taking their time today. Like I said, I know it's a lot of information to take in. It's a lot of things to think about, a lot of things to think about your role that you play as a judge or a court within, child welfare funding, because it's funding that's received for another agency, but an agency that you regularly interact with within your court system. And as we see, there have been changes over time to, child welfare funding sources, in part because of the things that we're seeing in the court systems. Like, how do we start to prevent removal? Okay, so let's add some prevention. And then even like one of the things we all know, the timelines, right? So it was 12 months to permanency, but we all know that, you know, that doesn't align what's known about addiction and you know, addiction services, that it doesn't just take 12 months for someone who may have been addicted since the age of 12, 14 to something to like, do recovery in 12 months time on top of what all of you judges know and see in case plans is other requirements besides just a treatment program, maybe parenting classes, maybe finding a job, getting housing, all these requirements that we're putting on, and then they're having to follow this timeline of 12 months to 14 months in order to not have their parental rights terminated.
And Judge Fine just put a nice comment in here and said through this, I think she might have been talking about training through their state training dollars. Many states provide training to their state court judges, and they are often sometimes willing to allow tribal judges to attend these trainings. And someone said they really appreciate this presentation because funding was always a tightly held secret by the agency until the recent changes.
Yeah, and one of my recommendations for judges is to, if your child welfare agency has a policy and procedure manual, ask if you can get a copy of it. See what requirements that they're having to meet. Um, really gives you some insight into what's going on. And some of what you'll find is the language from these funding requirements is directly put into the policy and procedure manual. Also, we do have another training webinar after this one about how courts can support caseworker turnover. And one of the things we'll talk about is, these requirements that social workers have to meet in order for these funding requirements to be met.
And I did put in the chat that someone had asked for the slides, and we will share those with you all after the webinar. All right. Well, might get done 6 minutes early. Give everybody 6 minutes back. I don't know if we.
I think our
Oh
last
yeah, there
slide
you
is
go.
just our contact
Yeah, so
information.
if anybody had any direct questions and you didn't get a chance to, or you think of some later, like Johanna said, I know this is like a lot of information and you might be thinking of things. Here's our contact information. If you need to ask questions, also you can request technical assistance directly from NYJA at their website or on that number as well. And thank you guys all so much for taking the time to be here. We know you're all so busy and hope that this was helpful. And like Johanna said, we will be having another webinar. We haven't had the date yet. It's either going to be in November or December, but we'll make sure that you guys also get that flyer. So if you're interested in that training, you can join us as well. All righty. Well, thank you guys so much for joining us.
Thank you all. Have a good rest of
Bye.
your week.
Ready? Goodbye.